Today, we're going to pull back the curtain on this invisible framework that governs every single medical interaction you have. We're talking about health law and medical liability. You know, the system that's designed to make sure your care is not just effective, but also safe, ethical, and accountable.
It's a question we almost never think about, but it's so fundamental. I mean, when you put your trust in a medical professional, you're not just banking on their expertise, right? You're actually being protected by a really complex system of rights and obligations. So, what exactly is that system?
Well, the answer is health law, and you can just think of it as the official rule book for all of medicine. It's the set of laws that lays out the rights and the duties for everybody involved, from the doctor and the hospital to you, the patient, and even the government, all to make sure that medical care stays legal and ethical.
So, here's how we're going to break it all down. We'll start with those hidden rules of medicine. Then we'll look at the 3 pillars that support safe care and, what happens when things go wrong. We'll dig into the 3 types of responsibility and the anatomy of a medical error. And finally, we'll wrap up with what all of this really means for you.
Okay, so let's just dive right in. The entire system of health law is actually built on a really powerful idea, and it's written right into the Mexican Constitution. You have a right to the protection of your health. That idea, it's the bedrock for everything we're about to talk about.
And this right is defined incredibly broadly. Health law isn't just about, treating you when you're sick. Its real goal is to protect your complete well-being, physical, mental, and social. And it does this by regulating doctors and hospitals, enforcing standards, and, at the end of the day, aiming to prolong and improve the quality of all of our lives. Now, to hit those big goals, the system actually rests on 3 pillars that are all connected. See, it's not just about laws on a piece of paper. It's a combination of rules, conscience, and practical goals all working together to keep you, the patient, safe. And you can really see how these pillars balance each other out. Health law, that sets the black and white rules you just can't break. Bioethics, well, that's like the conscience of the system. It's what asks the should we questions. And patient safety, that's the practical, boots-on-the-ground application of both. The actual things people do to prevent harm. You just can't have responsible care without all 3 working together. But what happens when this framework breaks down? When a patient gets hurt, not because of their illness, but because of the care they received. This is exactly where the concept of medical liability comes into play. To put it really simply, medical liability is the professional responsibility that kicks in when a healthcare provider's action, or maybe their failure to act, ends up harming a patient. It's the system's way of dealing with mistakes and making sure there's accountability. Let's make this really concrete with a case. So imagine a surgeon is doing a planned prostate surgery. In the middle of it, they see something they didn't expect. They make a split-second call to expand the surgery, going way off the original plan. The huge problem? They never got the patient's consent, and the result is permanent, life-altering harm. This is precisely the kind of devastating situation where medical liability becomes absolutely crucial. So, when an error like that happens, the consequences for the doctor aren't just one size fits all. The liability can actually be handled through 3 totally separate legal paths, and each one has a different goal and a different outcome. And here's a quick look at how the system tackles these errors. The goal of a civil action is to repair the damage to the patient, and that's usually with money. Penal action, well, that's for the really serious errors that are actually considered criminal conduct. And administrative action is all about the system itself, making sure the hospital or the clinic is following the rules. So, 3 different goals, 3 different sets of consequences. First up, you've got civil responsibility. The main focus here is just repair. It's based on the civil code, and the whole goal is to make the patient whole again, which often means financial compensation for things like extra medical bills, lost wages, and even moral damages. Next is penal responsibility. And this one is way more serious. It comes into play when a medical professional's actions, or maybe lack of action, are actually classified as a crime. The consequences here are not just financial. They can include huge fines, having their medical license suspended, or even jail time. And finally, there's administrative responsibility. This one is all about making sure the healthcare system itself is playing by the rules. It's about sanctioning violations of technical or legal health norms, things like a hospital having incomplete patient records, or its building not being up to code. The goal here is just to make sure the institution is running safely and legally. Okay, so we know there are consequences, but what kind of mistakes actually trigger them? Well, the law is super specific about this. It breaks malpractice down into 3 distinct types of failure. To really get it, we need to know the difference between negligence, imperetia, and imprudentia. So first, let's talk about negligence. And the key word here, the one to really remember, is omission. This is when a professional knows the right thing to do, the standard of care, but they just don't do it. They had a duty to act, and they failed to act.
This case makes it crystal clear. So a patient comes in, doctor correctly diagnoses them, prescribes penicillin. But they omit one critical step. They forget to ask about allergies. That single omission, one simple question, directly causes a life-threatening reaction. The doctor had the knowledge and the duty to ask, but they didn't act on it. That is the very definition of negligence.
The second type is imperetia, which basically translates to a lack of skill or just plain incompetence. Now, this isn't about forgetting a step. This is about not having the basic knowledge or ability to do the job right in the first place. Just look at this timeline. A patient shows up with classic heart attack symptoms, but an inexperienced doctor who just doesn't have the fundamental skill to recognize the signs writes it off as a stomach problem. That huge delay in treatment leads to irreversible damage. You see the difference here? This wasn't forgetting a step in a process. This was a fundamental gap in the knowledge they needed to do their job. It was a failure of competence. And finally, we have imprudencia, or what we'd call recklessness. This is all about taking a foolish, unnecessary risk. The professional knows, or they absolutely should know, that what they're doing is dangerous and totally unjustified, but they go ahead and do it anyway. It's an error of doing something, not of forgetting something.
This is a perfect example. Putting in a central venous catheter is a high-risk procedure. It requires a specialist. Any general doctor knows this. They know it's way outside their lane. But in this case, the doctor decides to try it anyway. That's not a lack of knowledge. It's a conscious, reckless decision to take a dangerous risk. And that is imprudence. So, okay, we've broken down all these legal ideas and potential mistakes. What's the big picture here for you as a patient? Well, it all comes down to one thing: building a system of trust. And you do that through accountability. And this brings us to probably the most important takeaway from all of this. The law is realistic. It knows medicine isn't magic. A doctor's duty is what's called an obligation of means, not of results. This means they can't promise you a cure. But what this entire legal framework does promise is that they must use every appropriate tool, skill, and standard of care while they're trying. It's this guarantee of professional diligence that builds trust and ultimately pushes the entire healthcare system to be safer for all of us. So this whole framework of law, ethics, and accountability is quietly working in the background of every single appointment and procedure. The question to leave you with is this: now that you know this robust system exists to protect you, does it change how you see your next conversation with a doctor, a nurse, or a hospital?